here to talk with you about estate planning essentials. So I'm going to keep everybody muted. I'm going to, after Ruth Ann has an introduction, I'll put the poll on the screen. Thank you for coming, and let me know if you have any questions. Thanks. Ruth Ann.
Okay, thank you so much, Karen, and it's exciting to be part of this first webinar. I'm happy to present a program on essential estate planning documents. And, you know, this, I think, kind of arises in all of our minds. These are some uncertain times. It makes us think about the future and potential issues. There are affairs in order. But I think we have to keep in mind that all adults should have this on their to-do list, even when there's no imminent crisis, because these are important documents to have in place for everybody over 18, I would say, because we can't do estate planning once we become incapacitated or too sick to do so. And we want to the degree that we want to control our choices and who can act on our behalf and where our assets go at our death, we need to plan ahead. So that's kind of where I'm coming from in putting this forward today. I want to just remind you that I'm not giving any legal advice today. This is really an informational seminar. If you have questions related to your specific legal situation or your particular family situation, I'm not able to answer that type of questions. This isn't a one-size-fits-all type of area of law, but I want to share advice so you know the terminology and you understand what the purpose of the documents are. And I'll give you a little roadmap of what I'm hoping to accomplish or what I'm hoping to get through today. At first, we're going to talk a little bit about some myths that are out there. I think there's things that we hear that we think might be true, or we're not quite sure what the terminology means. So we're going to talk about some myths and then some legal terminology. So we're all on the same page when we're talking about legal jargon. I know it can be very confusing. I want to give you some information about what the words mean that we're using, and these will all be in the handout. So you don't have to take furious notes. You're going to get all these by email. So just, you know, sit back and soak it in. After we go through the legal terminology, we're going to talk about a couple of essential lifetime legal documents. Then we're going to go on to wills and some information about wills, and then close with a question and answer. I want to leave plenty of time for the question and answer at the end, because I know all of these topics do raise questions. And as Karen mentioned, if you have a question that, you know, feel free to ask a question as we're going along, and Karen's going to be my right-hand person here to determine whether I'm happy to answer questions if they pertain to exactly what I'm talking about at the time, or we can batch them till the end. So feel free to ask questions along the way, and Karen will, maybe some people have a lot of the same questions, so maybe there'll be some common things. So I'll rely on Karen to let me know what to answer and when. So starting off, let's talk about some myths. I think.
Ann, did you want me to do the poll?
Oh, yes. Let's do the poll. Karen has a poll. I have a poll that Karen's going to administer. I just like to get a little bit of an idea of where everybody is in relationship to exposure to, experience with estate planning. So take it away, Karen.
I have posted it. It should be on your screen. I don't see any responses yet, so I'm hoping, oh, there we go. Somebody is responding. Good job, everybody. Okay. We have 9 of our 13 participants. Tish, I know you can't do this.
I can see it too, Karen, so this is good.
Okay. All right, I think I'll end the polling so that people can see the results. Okay, all right, there you go, Ruth Ann.
Okay, perfect. Thank you. Yeah, so common kind of a mix, some experience with estate planning, some not. I like to see that people have healthcare directives, et cetera. So we'll keep going through here, but thank you for participating in that poll, those of you that are on the computer. So again, starting with some common estate planning myths, just to get us all on the same page here. It looks like I have kind of a savvy group here who has done some estate planning. So maybe some of these myths are you already know that they're myths, but I think a barrier to estate planning sometimes can be that you don't have an estate, right? I don't have an estate. What's an estate? I'm not wealthy. That's not the determining factor if you need someone to make decisions for you if you become incapacitated in the future. So any amount of money that you have, a checking account, real estate, whatever, you have an estate if you have anything that's titled in your name. Is estate planning best done when you're seriously ill or dying? Well, it's good to get done, but for your estate planning attorney, it's not so great when you're seriously ill or dying. I mean, don't wait too long, folks, is I guess the advice I would give there, or the information I would give there. You have to have legal capacity to do these documents, and if you're in and out of consciousness or losing capacity or have a progressive disease that maybe dementia or something, it's going to be much more difficult to get those documents in place in time. So another myth, some people say, well, my family knows my wishes, so I'll just let them take care of things. They don't have legal authority to access or take title to your property in order to distribute it. So that's not a substitute for an estate plan. Do-it-yourself estate planning is a cheaper alternative. Yes and no. It sounds self-serving if I debunk do-it-yourself estate planning. I realize that, but a lot of the sites out there don't take into consideration that these documents are all state law specific by state. So, and the legal jargon can be confusing, and it might sound right to, just our regular vocabulary, but there are legally operative words that mean something different, even if it's the same word. So I've had to fix some that people thought were valid, and it was more expensive to fix them than it would have been to get an advice, the advice of an attorney ahead of time. So I would just say it's not necessarily a cheaper alternative. Not everybody needs to get exactly the same amount out of your estate. Some people feel that they can't make their kids happy because everything has to be equal. I'll just kind of leave that one there. There's lots of different ways to leave your estate. So you don't have to leave everything equally, depending on lifetime gifts. Let's say maybe somebody got the family business and the others didn't. So maybe that's something to consider. This is a common one. If you have a will, you avoid probate. We're going to go over probate at the end, but let me just say that if you have a will, it will go through probate, depending on how your assets are titled. So probate, having a will doesn't avoid a probate proceeding, a court proceeding. Okay, a few more. I'm not going to cover trusts today because I only have an hour, but I think a very common myth is that if you put assets in a trust, then that protects them, that shields them from paying for long-term care expenses, for example, or high health care expenses later in life. And it doesn't. Or that estate planning is a one and done process. It can be, but you can also change your mind. All these documents are amendable, they're changeable. So Don't feel, I think some people wait thinking, well, I can't make a decision now, or my thoughts might change, so I better wait and do my will late in life when my decisions won't change. And I think it's better to get it done earlier, knowing that things can be amended. There's no gathering like in the movies where everybody sits in the leather chairs around the desk of the attorney and we read the will to everybody. I put that in there as a little bit of humor, a little bit lateness. We don't do that, just in the movies. Another myth might be that you can avoid estate planning by just transferring all your assets to your children before you die, and then everything is protected. It's possible, but there are pros and cons of that, because then your children own all your assets for one of them. Another myth might be if you have a power of attorney document, you don't need a will. You'll learn through what we're gonna cover today how those two differ. And kind of the proxy question, if you're the spouse or the parent or the child of someone, do you legally have the right to act on behalf of them just because of you're their spouse or child or parent for financial or healthcare matters? No, there's no automatic proxy in Minnesota. You don't, hospitals often will work with a family member without a healthcare directive, but that's really, we'll cover that in healthcare directives. They're not legally named to do so. Okay. A few legal terms here, and I'm not going to go over these too specifically because it's already 12:15, and where does the time go, right? So a will, living trust, an estate. I think we covered that. What is an estate? It's all the property owned by a person. Real estate, personal property. What probate is, personal representative. I should have put also executor. That's the term it used to be called in Minnesota, executor, but now it's personal representative. So it's that person you name in your will to administer your estate. And what's a beneficiary? These are all kind of will related. A beneficiary is a person or entity designated to receive property under your will or trust or another financial asset. So keeping those in mind, then we're going to talk a little bit about powers of attorney and healthcare directives. So this first column, a power of attorney, what does that do? That's a lifetime document along with healthcare directives. So a power of attorney, think financial, think dollar signs when you think power of attorney. There's, it's a legal agreement that authorizes someone to handle the financial matters of another person. And it's only valid during the principal's death. I know when I was probably in high school or college up here, my mom could go to the Grand Marais State Bank and talk to Joanne Staples and say, Ruth Ann needs me to deposit or to transfer this from her account to my account or whatever. And it was informal. Yes, you could probably do that back then. Well, times have changed. As those of us with kids know, once they're 18, you don't have any legal authority to help them with anything. You don't even get their grades. But so a power of attorney, it legally authorizes someone to handle your financial affairs if you are unable to, temporarily or permanently. And that person that you name is called the attorney in fact. Very odd term. It doesn't have to be an attorney, and it doesn't make that person an attorney, of course. But it's the person who receives the powers that are allocated. We're going to go over this in detail in a little bit here. So with a power of attorney for financial matters, think of that attorney in fact, someone that you name, that you trust, that would act for you financially. On the other side of the column, another lifetime document that's important is a healthcare directive. Has nothing to do with financial matters. It's a legal document that sets forth your wishes regarding medical care and treatment and who you name to speak for you regarding those matters if you're unable to on your own. So that only takes effect if you are unable to make your own healthcare decisions, if ever. Sometimes people never lose the ability to make their own healthcare decisions, but temporarily or permanently, if your physician determines that you're unable to speak on your own behalf, this document chooses you choose, you control who speaks for you, and they then have that authority. And those are agents that you name. That person's, that role is called a healthcare agent. So those are those two documents and those legal terms associated with those. So now I'm going to move to these two lifetime documents, the powers of attorney. We covered a few of these things already here, but let's talk about who you name and how you name them. You can name more than one attorney. In fact, often if there's a spouse, the spouse is the first one named. And then I always want to back up, because what if your spouse is not available, or that your first person that you name, what if they're not available to act for you? A backup. Maybe that's a trusted friend or a sibling or a child, depending on their ages. I like, sometimes when we create these documents, we have siblings that are our age and it makes sense, but we want these documents also to have some longevity. So thinking about someone in the next generation, maybe it's a niece or nephew that has some financial skills. They don't have to be a CPA or anything, but they need to be trustworthy and able to keep good records and act, in your best interest. So you can act more than one to act together, and they could act jointly or independently. So there's a lot of choices there. And to execute a power of attorney, they're required to be in writing and signed by you in front of a notary, dated, clear on what powers are granted. There's a section that the statutory form, and this is the one I'm talking about. In this case, there's like A through N listed powers, and we often check N, all powers, but you can limit the powers if you want someone only to act for you. Let's say for tax matters, maybe some of us have signed those with our CPAs for acting for us with tax matters, et cetera. So there's some options there. It has to be clear regarding whether the attorney, in fact, that person acting for you, can transfer your money to themselves. Sometimes that's appropriate for the spouse, but not for anybody else. So you have to be clear in that regard. And also whether there are accounting responsibilities and how often that attorney, in fact, has to account to you. So kind of a long list there, and I'm going through it pretty quickly, but just want to cover all the specifics. Okay, I've talked about a few of these. You can limit some of the powers. You can, to the degree that you'd like, you can specify an expiration date. But for estate planning, we don't really want an expiration date because we don't know when it would expire, when we'd want it to expire. We really want it to be in place if you become incapacitated. So sometimes we hear about a durable power of attorney. What does that mean? It means that it continues to be effective if the principal becomes incapacitated. So those are recommended. And it's interesting to note that whoever you name isn't legally required to act on your behalf. Another reason to have successor's attorney, in fact, named, because maybe someone, they're named, they're in first place, but their life is in chaos, or they just had a child, or they're traveling internationally or something. They're not legally obligated to act. So then it would go to the next person on the list. And let's see, I don't want to go into too great of detail. What happens if we don't have a power of attorney? I think this is important to note because I'm telling you why you should, but what happens if you don't? If you become incapacitated and you haven't prepared one, and someone needs to act for you financially, let's say, sell your house or transfer a vehicle or do something like that, transfer an asset on your behalf. Without a valid power of attorney in hand, there may have to be a court proceeding for a conservatorship where someone's becoming incapacitated and there's no one authorized to act. It takes a court proceeding, and there's some delay in getting that done. So it's heartbreaking to me to see those cases when a simple kind of pre-planning power of attorney document could have handled that. So, okay. Moving along to healthcare directive. I would direct you to Dr. Jenny Delfs did a great video, and it's up on boreal.org. If you scroll down a little bit, there's a picture of Dr. Delfs, and she gives an outline of healthcare directives and everything. So that was put up maybe last week. Time's so elastic. It seems like last year, but maybe that was last week. So I would recommend that you watch that because she covers that in great detail. I'll just briefly go through, and I see that a lot of you have healthcare directives, so kudos to you. That is an important document. It's a written document that informs others of your healthcare wishes. Again, you name an agent as we talked about. It has to be in writing and dated. It must contain your name, be signed by you or by someone you've authorized to sign on your behalf. And it must be notarized or witnessed by two witnesses. And it must either name an agent or healthcare instructions. The best, of course, do both an agent or agents and healthcare instructions. My same advice or information really applies to this too. Name an agent and some backup agents too. They can act together, they can act individually. Doctors don't like when we specify that people act jointly. Like if I had my two daughters acting jointly, what if they couldn't get a hold of one, or they disagreed with each other or something based on what they think my wishes would be. So it's best to have a sequence of agents in descending order. What you should include, of course, the names, contact information, your goals, preferences, and values, the types of medical treatment you do and don't want, whether you're an organ donor, tissue donor, etc., whether you would like to be cremated or traditional burial. Sometimes I put in cemetery plot information for people, whatever they have, funeral arrangement preferences, etc. I also wanted to note that there are a lot of types of forms out there. Honoring choices, I think, is the one that the clinic provides. There's a 5 wishes form. There are others. We have our own. Our firm has our own 2-page healthcare directive. So a lot of different ones are out there. I would just say that I know the honoring choices is a great form. It goes into great detail that might be really helpful for your agents, but the important part is to get it signed and notarized and into the hands of your agents. I think some of those existential questions that are in that document can impede our completion of it because we want to think about it. We want to sit and think because there's, some big choices to make, but those are considered optional pages, and it says optional at the top. So I just, if you're going to fill one out, I would just say you can always fill in that other information later and get it to your agents, but don't let that be the barrier to get it completed. A healthcare directive is not a DNR, DNI. It doesn't instruct like an EMT coming to your house that you don't want to be resuscitated. And it's not a POLST. As some of you are familiar with POLSTs, which is a provider's order for life-sustaining treatment. Those are documents that you complete with your physician. And if you wish to have a DNR, do not resuscitate type of designation, that's the appropriate form for that. So I just want to make that clear. Okay, what limits are there to my healthcare directive? Your agents have to be at least 18, so keep that in mind. And your agent can't be your healthcare provider unless your healthcare provider is a family member. So, and you cannot request assisted suicide in Minnesota. That's not allowed in Minnesota at this point. It's effective when it's properly created and signed, etc. And when as I said before, when your healthcare provider determines that you're unable to make your healthcare decisions about yourself, then that's when your provider would go to your agents for asking what you would want. And it can be temporary. I mean, it can be used temporarily. Let's say that you're in a situation where you can't make your own healthcare decisions, but then you regain your capacity, then you regain your ability to make your own healthcare decisions. So, if you're in if I trip and you know, and am unconscious and somebody has to make a decision on my behalf, great, use that healthcare directive. And then if I gain the capacity, then I would gain my own ability again, and then my agent steps back. So that's all about healthcare directives. What happens if I don't have a healthcare directive? Similar to a power of attorney document, family members do not have automatic proxy to make healthcare decisions on your behalf if you're unable to. You know, if you're going to the clinic or the hospital here and you're a known person and have, you know, been with your provider for a long time, I would bet that they're going to involve the family in the decision making, whether or not you have a valid healthcare directive on file there or with you. But in Florida, you might have a very different situation. You might remember the Terry Schiavo case where it went to the Supreme Court twice, I think. It was a battle between the spouse and the parents of a young woman in her 20s who was in a vegetative state, and the husband was sure that, you know, she did not want any heroic measures to just stay alive. That wasn't a quality of life in her mind, but the parents wanted her to stay plugged in, as it were, in case a miracle occurred. And I think eventually the spouse won out, but that was an unnecessary involvement of courts when a healthcare directive could have really been so useful in that situation. So if you don't have one, you may have to get a court proceeding for a guardianship. Your family would have to if decisions had to be made on your behalf. So that's what happens if we don't have a healthcare directive. Karen, are there any questions that have arisen on powers of attorney or healthcare directives? Because we're kind of turning the page here to wills.
There have been no questions.
Boy, either everybody's asleep or I'm crystal clear or somewhere in the middle. So, okay. I will
Wait,
go with,
I just got a question.
okay.
How often should healthcare directives be reviewed?
That's a great question. I would say, you know, we send a letter to our clients every 2 years, just reminding them it's been a 2-year interval since they executed their estate planning documents, because I think time flies and we think, oh, we just did our estate planning. And it's like, oh, 8 years later, you know, it's like, really, it's been 8 years already. So anytime, I think, you know, on an interval like that, or if, you know, if somebody in the family, you know, changes, you know, situations, someone passes away or someone moves away, or your relationship with those people that you once had that trusted relationship with you changes for whatever reason, I think those are all good reasons to review all of your estate planning documents to see if your choices still are appropriate. But I would say on average, we see modifications probably on average 5-6 years. You know, people move, their contact information changes, phone numbers, the order that people wish their agents to act in changes. So somewhere in there, as often as needed, but, you know, at least probably every 2 or 3 years, at least peek at your documents. Anything else out there?
No, not yet.
Okay, so that first part of the presentation was on lifetime protective documents. Now we're going to switch gears a little bit to talk about wills, which of course take effect at death. First of all, just let's talk about what is a will. It sounds like it's pretty basic, but let's start at the beginning. A will is a simple way to ensure that your money, property, and personal belongings will be distributed as you wish after your death. Simplest definition there of what a will is. And it allows you to appoint a specific person or persons to handle your estate at your death. Anybody remember what that position is called? Little pop quiz here. Personal representative, okay? Used to be called executor. So those terms are kind of used interchangeably. However, the current legal term is personal representative. The law doesn't require you to have a will. So we'll talk about what happens if you don't have a will. If you die without a will, Minnesota inheritance laws control how your estate is divided. Now, this came true in spades recently for Prince, which it's just astounding that he didn't have his estate planning done, because he certainly did have an estate, continues to have an estate, and I don't know when that estate will ever be totally administrated because it's a mess. So his estate, because he didn't choose who got his assets, went through the intestate statute. So we'll talk about that in a minute, exactly how that passes. Well, I'll cover that right now. Because I think it's coming up, but it's in my notes here. So if you don't have a will, it would go to your closest relatives who survive you. And so once it finds a place to go, a relative or closest relative, then it stops there. It doesn't divide it amongst all of your relatives. So if you have a spouse that survives you, it goes to your spouse. If your spouse doesn't survive you, well, I'll put an asterisk next to spouse, because if it's a second marriage and you have kids that aren't those of your spouse, I'm not going to go down that rabbit hole, but anyway, okay, spouse first. Your kids, if your spouse doesn't survive you, it would go to your kids. If your spouse and kids don't survive you, it would go to your grandkids. And if nobody lives in that sequence, then it would go to your parents, which that's kind of an odd result, but I've seen that where suddenly a 96-year-old grandma or, parent in the nursing home, because someone wasn't married and didn't have any kids, died with a living parent and didn't have a will, so went to the living parent. It then goes, if no living parents, then it goes to siblings and half siblings, and that's where the Prince estate landed, is amongst Prince's siblings and his half siblings, some of which he did not even have any relationship with. So that was an odd result, and something that I'm sure if someone would have pointed out to him, maybe they did and he just didn't act, but that was not the result that he wanted. And now, of course, all of those siblings and half siblings are fighting over what was probably never intended to go to them in the first place. But anyway, so an unfortunate result there. And if no siblings or half siblings, then it would go to nieces and nephews and kind of on down that line until it found a category of people to distribute things to. And for some people, that's fine. I mean, that's exactly what they'd want. But if that's not what you would want, then it's really important to have a will to really carry out your wishes. So what rules apply to wills? To make a will, you must be 18 or older and have the capacity, and you must intend for the document to operate as a will. So what's capacity? Let's talk a little bit about what legal capacity is to execute a will. We talked about, should we wait until we're old? Not necessarily, because you need to be oriented space and time, kind of like, do you know what day it is, what year it is? And of course, now a lot of us who have been staying home a lot have those challenges. What day is it? But oriented to space and time, a knowledge of what you own in general, what your assets are, and who would likely be the recipients of your estate. You need to be able to hold those in your mind long enough to make a logical determination of how you would want those to pass. So that's how legal capacity is really determined. And here it comes. Must understand the nature, situation, and extent of his property and the claims of others on his bounty, really antiquated language here, or his remembrance. That's the legal definition. Okay, let's talk about the basic elements of a will. It's your name, where you live, any specific gifts or assets to specific persons. Those specific gifts go out first, and it can include your tangible personal property, your stuff, that things that don't have a title, things that you might think might go through an estate sale, something like that. You can have a separate list that names certain aspects, items to go to certain people, like if there's an heirloom or jewelry or something that somebody really wants, you can name that on a list. It doesn't have to be done at the same time as the will, but in my mom's case, it was great that we found her list, because we have some family heirlooms that have been passed down for many years, and it helped us know where she wanted it to go, to whom, which of my siblings, so that we didn't have to make that determination ourselves and determine who got what. We have a carved Norwegian box that's been handed down in the family since the date on it is 1648. So it's old and getting older. And so mom was specific about who got that, who got an antique spinning wheel from Sweden, from the Hedstrom side of the family, etc. So that was very helpful, and it helped us not to have to fight over those things. Another element of the will, the name of your spouse, children, or your other beneficiaries, or charitable distributions, all of those things, all of those choices that you can make, who you nominate as your personal representative, and a backup probably. If you have minor children, this is a really important thing. This is often kind of the entree into estate planning for young families, is naming a guardian for minor children. If something happens to both you and your spouse, what happens, who's the guardian, and who takes care of the money, and a creation of a trust for that money for the kids. So can't go into too much detail there, but that's important for young families. And of course, a will includes your signature, and it must be witnessed by 2 witnesses. So basic elements. The information you have to gather to prepare a will that's good to have in mind, a little bit of homework to think about, is your objectives, really, how you want your assets to pass at death, what percentages, equal to your kids, any specific gifts to others, etc. What your assets are. This is a really important aspect, because sometimes it's hard to get our minds around what goes to whom unless we really know what it is that we have. And we forget about retirement accounts sometimes, or life insurance, or real estate that we own with other people, what debts we have and how that would impact a gift maybe going to a child if there's a debt associated with it. So that's really important. Again, that list of who you'd want to receive your assets at your death. A family tree, of course, that's not part of your will, but it helps to review with your estate planning attorney, just to determine how your estate would pass if you didn't have a will. And maybe if you have any specific concerns about anybody, maybe somebody has a spending issue, maybe somebody has an addiction issue, maybe somebody shouldn't get their inheritance all at once. Maybe it needs to be meted out over time. You can control all those things. And maybe there are people you want to omit because maybe they've had lifetime gifts, or for whatever reason, you can omit them by name. So thinking about those things is important in terms of thinking about creating a will. What does a personal representative do? And it's good to talk to your personal representatives ahead of time, and don't spring it on them later, because they might not want to act, or they might have questions, and it's better to ask them up first, ask in ahead of time. So what will they do? They'll file your will with the court if necessary. They'll inventory your assets, work with the attorney to run through the probate. They'll pay your valid debts. They'll file your tax returns for you, and order death certificates, etc. Canceling credit cards, distributing your assets. They're not legally obligated to act. So if you name someone and they say, I really, at the time of your death, if they say, I'm really not available, maybe they've aged out of that position, or maybe they no longer have the capacity, or they're living off the grid in New Zealand. It's hard to say. That's why it's always good to have successors, and think about the ages that you're naming, and the financial abilities. Trust companies or banks with trust departments can also do this type of work if there's not a trusted financial person in your life. And, it doesn't have to be that complicated. They don't have to be a CPA or anything, but, there are there's record keeping involved, and they can hire people to help them, et cetera. But think about those things. It doesn't always just have to be your oldest child followed by your next oldest child. It is a job. So those are things to think about in terms of naming a personal representative. A will is valid and effective unless you change it or revoke it. So it is important to review it periodically. And this kind of goes to the other question about healthcare directives. How often do you need to review it? And you may want to update or change your will or other estate planning documents, really, if any of the following take place. So your marital status changes. That's an obvious one, but it bears repeating. Or you have a child that your initial estate planning documents, you didn't have any children, and now you have a child. So, usually you don't have to update it every time you have a child, but because we kind of put language in there that includes afterborn children, but still it's important to review things. Maybe one of the beneficiaries you've named has died, so you have to consider whether you want to change your asset distribution, or if it provides for what happens in the event of the death of that beneficiary. Or you move to a different state. As I said, these documents are state specific. So you want to make sure that your plan is compliant with any state that you move to, and especially the power of attorney and healthcare directive will have to be updated. If your assets change significantly, maybe the plan that you're currently in isn't still appropriate, so it's a good time to assess that. Your selection for PR no longer represents your wishes, or there's a change in the law that affects your will. We try to keep on top of that for people. So quickly, how do we change our will? Do we, by show of hands, and of course I can't see your hands, so you don't have to use the hand raising things. Do you just write all over your will? Trick question. You have to follow legal formalities, and you can either write a new will, or you can create a codicil, which amends a portion or portions of the will, which should be kept with the original will. So can I just cross out language or write in new language to change my will? Please no. It adds ambiguity to the content. Remember those formalities that we talked about, how it has to be witnessed and signed in the presence of these two witnesses. If there's just language all over the will that's crossed out and rewritten, it's really hard to determine from the court's position whether that's a valid change, or if there's no witnessing, who made those changes even, or did the person have capacity to make those changes? So don't mark on your original will. The only thing that you can update that's separate is that writing that we talked about, that tangible personal property list, like the one my mom had that gave the Norwegian box to my brother. No, that was fine. So that can be updated without changing the will itself, and that can be worked on lifelong. So that's something, that's an exception. We talked a little bit about what happens to a will after you die, and it often goes through probate, which is the legal process to transfer your assets to the individuals who are to receive your assets via that personal representative, that person you've named. They're the person that steps into your footsteps and distributes those assets. They have to be authorized and by usually a court proceeding, because you nominate them in your will, but they have to be sort of verified by the court. And if people can contest it, I mean, if your beneficiaries think that your personal representative won't do a good job or something, they do have a forum to raise that question or to debate that or dispute that. So it involves a number of different steps. There's a petition to the court. There's that publication of notice in the paper. Maybe you've seen it on the back page of the Cook County News Herald or other papers, those, notice of probate. And that's a required step to give notice to creditors who have 4 months to state any claims against the estate before the estate is distributed. Creditors may have priority based on what their claim is. So those are some of the steps. But All of these formalities are outlined in what's called the Uniform Probate Code in Minnesota. So that's chapter 523 of the statutes if you need something to help you sleep at night. So it is 12:50 and I'm right on time here to open it up for questions.
I have one question.
Yes.
This is Karen talking. If you don't have a will at all, how long would it typically take if using an estate attorney to get a valid document completed? Also, what are the cost ranges for getting these documents, wills, healthcare directives completed?
Okay, time frame. So if you are starting from scratch and don't have any estate planning done or whatever, every estate planning attorney is probably going to be different. I will say that I can only speak from my own experience, and it kind of depends on, you know, what is already in-house, but I would say right now I'm turning things around in about 2 weeks, as long as, you know, I have all the information I need to draft your documents. So you've done that homework, you know, that list that I gave you earlier in the seminar about what you need to have gathered ahead of time. We have a questionnaire that gathers this information for you. And once that's complete, we have an initial meeting. As a follow-up to that, there might be some more information to be gathered, but I draft documents, they go to you for approval. And if everything's great, we schedule a signing conference. Of course, signing conferences have gotten a little more challenging in all the requirements of the COVID-19 virus, but I'm working with people. I mean, we're observing all the sanitation recommendations in our office, maintaining social distances. We've put 2 conference tables together, so we're really far apart from each other. I know we're also, we haven't done this yet, but we've offered kind of a drive-up service. So if you really don't want to come into our office, and there's only 2 of us in our office, and we're actually working remotely from one another. So I'm, you know, so the office is a very clean place. But if you want to do a drive-up type of a thing, we can also do something like that. So I would say 2 weeks. 2 weeks is probably, or a week and a half is probably the tightest that we could put something together. But it's, you know, it's a pretty quick turnaround if we have the information. Cost range. Now that's always a tough question to answer, because it depends on, everybody's situation is different. It's kind of like going to the doctor and not knowing what the diagnosis is going to be. You know, you just give them the symptoms and then they diagnose. But I would say that for a single person with a will and a power of attorney and a healthcare directive might be in the $600 range, hard to say. And, you know, there are estates that need complicated estate planning just because of the nature that they are, and maybe a trust plan, which we didn't go through at all today, might be appropriate. Those are going to be, you know, maybe triple or quadruple those single will trust, will, power of attorney, healthcare directive fees. But you know, my practice is to have that discussion with you and give you a fee estimate with, you know, in our first meeting, within, you know, the first conversation, because then I can determine really what is going to be required in terms of what's going to be needed on our end. And, you know, I don't want affordability to be a barrier to anybody. So I work with people if you know, and I know that a lot of people are really facing some financial challenges right now. And I just want everybody to know that I will work with you to make it affordable, you know, no matter what your financial situation is. But this isn't a commercial about me, but that's my answer to that question. Any other questions?
There aren't any in the question and answer right now. Anything else? I'm going to just double check. Anybody? You see how to have the, I'm going to unmute everybody. And if you have a question, you can ask it. Let's see how this works. Let's see if I can just unmute everybody at the same time. Okay. Everybody is getting unmuted. Kara, I can't seem to get you unmuted. Does anybody have any questions for Ruth Ann?
I have a question. This is Tisha. Regarding the questionnaire to fill out information regarding a will, is that available? Will that be available online?
You know, I can send that out with the handouts if you're interested.
I am. Thank you.
Okay, yep. And I should mention too, that I practice throughout the state. So not only in Cook County, but along the North Shore and in the Twin City metro area. So if you don't live in this area, or if you kind of are a dual citizen of more than one place, I'm happy to work with you in other areas too.
Thank you. I do live in Littleton, or we do. Thank you.
Okay.
What about, I have a question. What about husband and wife? Do you do one estate plan or do you do two?
What was that about spouses?
Do you have one document for both of you or do you do two different wills?
It's two different. Yep. That's a very good question. Everybody has their own will because we don't know, you know, they're reciprocal often if you're married, that everything goes to your spouse at your death, but we don't know who's going to die first. So everybody has their own will, even if they say the same things initially.
Okay.
So good question. Same thing with the power of attorney and the healthcare directives. Everybody's got their own set.
I have a question.
Uh-huh.
What if the spouse has property jointly with like his siblings and then the rest of the property is ours together? Should we resolve the issue with the other property first in terms of inheritance?
You know, that's kind of a specific question that it's hard to answer without knowing more, but it kind of speaks to me about an important question about titling. And we didn't have time to really cover that today, but I think what you bring up is a good point about what you own jointly. And if it's joint tenancy, you know, sometimes you own a property with your siblings, perhaps. Sometimes it's joint tenancy, meaning that if someone dies, it just goes to the remaining individual that are named as a joint tenant or joint tenants. It can be 3 people. And so that at the death of the, you know, the second person, maybe the last person on title is the owner of that property. Another way that real estate is held is called tenants in common, which is kind of the opposite of joint tenancy. So that let's say in that same example where 3 siblings owned a property together, if one dies, that third of the property actually has to be probated to get to maybe that person's spouse or children, etc. So that's an important
Good to
piece
know.
of information to gather when we're gathering that financial asset information is what you own and how it's owned, whether it's in joint tenancy with someone or tenants in common. But that is important information to discuss when we're talking about estate
You're gonna
planning.
have to talk to your sister about that. Oh, yeah, if it's joint.
Thanks.
I got to unmute me. Okay, I have 2 questions in the question and answers.
Okay.
One is, will you have a webinar regarding trusts? That's for you, Ruth Ann. Do you have information that you can present in a webinar, or have you seen good webinars?
I'd be happy to discuss trusts. You know, my usual like community ed seminars are like an hour and a half long. And so the piece that I had to take out of this one to fit an hour was the trust piece. So it kind of fits in there. It's another dispositive document like the will. It just does a little bit different work. So yeah, I'd be happy to put something together on trusts. I think I can direct people when I send my handouts out. There's the Minnesota Attorney General's office has a document or a publication called Probate and Planning. And it's available at the Minnesota Attorney General site, which I'll give you the web address here, www.ag.state.mn.us. And I know that publication covers a lot of the basics, including trusts. So if you wanted to look there, that has some good information that's Minnesota specific about trusts. I'll repeat that website, www.ag.state.mn.us. And so just look for, that. It's a publication called Probate and Planning. So, or email me. If you can't find it, I'm happy to send you the link to that. But yeah, I'd be happy to do a future webinar, perhaps if I'm invited back, about trusts.
All right, the next question is, do you recommend against siblings serving as powers of attorney?
Every situation's different. If you trust your sibling and they're a good choice and probably have the ability to do it for some time in the future. I would also, if they're 20 years older than you, maybe they're still the right choice, but then having a backup of someone in a generation, maybe the generation below that. But yeah, ask them first, depending on if, they feel that they would be willing to do that on your behalf, and maybe they'll reciprocally name you as well. But yeah, no, there's no reason not to, but there may be some reasons to or not to. So every situation specific. I'll just say, I know I had a client one time that said, well, I suppose I should name my oldest son. And, they sounded very disheartened about it. And I said, well, tell me about your oldest son. Why do you think you should name him? Well, he's the oldest and he'd be really offended if I didn't name him. And I said, well, tell me a little bit about him. How's his, does he have good record keeping abilities? Is he good financially? And, I think that person said, well, no, he's gone through bankruptcy twice and, whatever. I'm like, not the right choice. I don't care whether he'd be offended or not, that isn't the right choice. So, it doesn't have to be a relative, but if it is, then just think, am I doing this because they would be offended if I didn't name them, or are they really the right choice?
Okay, there's, if you have a question, please put it in the Q&A. Otherwise,
Hey there, Ruth Ann. This is Claire Smith. I had a quick question.
Sure.
okay.
So I had a question about investment accounts. Actually, being a financial advisor, I assign beneficiaries to their investment accounts. I'm wondering what happens if there is some type of a discretion between their will beneficiaries for their investments and what is actually done through their investment company.
Great question, Claire, and I didn't cover this, but okay. If you have a beneficiary designation on an asset, often those are IRA assets, your retirement assets, or life insurance, things like that. Those things pass by operation of law based on who you have as your beneficiary will receive that asset. Even if your will says something completely different, the will only covers assets that don't have a beneficiary designation. I should have probably made that clearer earlier on, but that's a great question, Claire. So it's another reason I think we ask about those assets and who the beneficiaries are in our initial questionnaire, because we want to make sure you don't have to have everything dovetailed. Maybe there's a reason to have beneficiaries to, to one set of people or whatever, and your will is going to go to charity or whatever. But you're right. If it the will does not supersede your beneficiary designations. Your beneficiary designations operate based on that contract.
Okay, are there any other questions? Oh, here we go. Is it necessary to reveal the dollar value of all your assets?
You know, I would say yes. I mean, I need to tell remind everybody that the information you share with me is protected by client confidence, and by, I can't share that with anybody, and I wouldn't. But the reason that we like to have at least a general estimate, and of course things change, as we know, the markets are volatile. We also talk a little bit about estate tax exposure. We didn't have time to cover that today either, but based on the size of your estate, we want to know whether we need to plan for estate tax exposure. And there are certain thresholds. Right now, the threshold in Minnesota is 3 million. That's where the exemption is. So few people are really caught in that estate tax net. That may change in the future. I mean, if Minnesota faces